Welcome everybody. Welcome to the people here live, also to the people that are tuning in tonight through our online option, or maybe people watching this at some time in the future. We're really excited to be able to present this special estate planning seminar for you. I'm Paul Snamiska, KML Lutheran High School's estate plan counselor. It's my privilege to be able to share this with you tonight. We're really excited to be able to have the opportunity to really learn a little bit about the estate planning process. And really to explain that tonight, we've got a special guest, attorney Rob Melick. Rob serves as an estate planning attorney, specializes in that area of law, and he's right in our area, and so he's very accessible. We'll talk a little bit more about that later on, but I really, really appreciate the opportunity to share this information with you. Before we start, I just want to emphasize a couple of things about estate planning. There's so many people today that just don't understand the value of it. I can tell you just on a very personal level right now, a family member in my life is dealing with a situation where there wasn't a will. And I can tell you the amount of stress, frustration, money that's going in because they have to now figure out how to handle all this. And quite honestly, the husband who didn't leave a will just didn't think it was that important. And now the rest of the family is really suffering because of it. And what a sad case. And so the reason we're sharing this information with you is to understand how important it is, and really not only how important, but I think how easy it is too. So I'm going to turn it over to Rob. I also want to encourage you, obviously present here tonight, but also online. If you have any questions, feel free to shoot those out. We're going to be stopping periodically and making sure those questions are addressed right away. There'll also be time at the end, but as we go through the presentation, certainly feel free to ask those. Love to have those come to you live and we can deal with them right away. So anyway, Rob, the floor is yours.
Thank you, Paul. I appreciate the opportunity to speak here tonight. Again, my name is Rob Melick. I'm an estate planning attorney. I've been an estate planning attorney for 14 years. I grew up here in Washington County. Sorry about that. Technical issue there.
Does for that. Again, my name is Rob Melick. I'm an estate planning attorney. I do have 5 offices in and around southeastern Wisconsin, and I am a Washington County native. So again, what I like to do tonight is just provide information. That's my main goal. In addition to my role as an estate planning attorney, I'm also an adjunct professor at Moraine Park Technical College. So instruction's kind of in my blood, so to speak. So that's my goal here tonight, is just to give you a little more information about estate planning, answer whatever questions you guys may have, and hopefully leave with a little more knowledge than you had before you came in. To kind of tie into Paul's point from the introduction, a lot of estate planning issues come from a lack of information. And again, that's my job to help bridge that gap. But what I can tell you is this: 90% of American adults do not have an estate plan. So for people who are listening to this presentation tonight, if you don't have an estate plan, don't feel badly. You're in very good company. A lot of people don't have that. In fact, 90% of American adults do not. And to also tie into Paul's second point, passing away without an estate plan often costs significantly more than creating one. One of the reasons why people don't create an estate plan, the main reason in my practice, is because people don't know what an estate plan can do for them. And again, that's my job to educate people about what an estate plan can do. But this idea of it costing money, again, sure, it's going to cost money to create an estate plan, but you end up saving significant sums of money as compared to the situation where you don't have your own estate plan. The reason I say that also is because courts, through the application of state law, have millions of dollars worth of unintended beneficiary assets available. Let me explain that in a situation that might be a little easier for you to understand. I'm sure everyone can relate to or have seen on the news at some point in time, call this number in Madison and see if you have any unclaimed money. Well, the overwhelming majority of that money is from estates. When people pass away, they don't have a will, they don't have a trust in place, and the money is just basically sitting there. That's what the overwhelming majority of that money is when they advertise that on television. So again, before I get into any specific issues about estate planning, I always start with these facts, just to give people a little bit of knowledge. And one thing that I'm going to say is this, and anytime I do a public speaking engagement, I mention this fact, and inevitably I'm going to see an eye roll or two in the audience. It happens every single time. Every single person over the age of 18 should have an estate plan. Okay? I'm going to start with that premise, that every single person over the age of 18 should have an estate plan. I'm going to qualify and defend that statement as we proceed here tonight. Powers of attorney. I'm sure most people have heard the term power of attorney, but what I found in my experience is a lot of people simply are unaware about what a power of attorney can do, or what it can do and how it operates. So it's those powers of attorney that I call the foundation of any well-drafted estate plan. Because, again, I go back to the statement I made that every single person over the age of 18 should have an estate plan. Powers of attorney are the main bases for me saying and defending that statement. So I'm going to walk you through a little bit of a hypothetical just to explain this a little bit. I'm going to give a 20-second biography about myself. I'm married. I have 2 sons who are 11 and 8. Okay? As 11 and 8-year-olds now, my wife and I being the parents of those children, if one of them has a medical issue, as their parents, we can make medical decisions on their behalf because they are minors. What happens when they turn 18? Okay, and I'm going to walk through this example. Purely based on birth date, no other factor whatsoever. I graduated high school at 17. I have a July birthday. My youngest son, on the other hand, has a September birthday. So I'm going to fast forward to September 3rd of 2030. The day my youngest son turns 18. He's in high school. He's just starting his senior year of high school, presumably living under our roof during that entire time. He drives to school that day. He's in a car accident. He's in a coma. He's taken to the hospital. Can my wife and I, as his parents, make medical decisions on his behalf? The answer is no. Can we even find out he's been admitted to the hospital? The answer is no. We don't possess that ability because the moment he turns 18, regardless of his circumstances, regardless of his living arrangements, he is an adult in the eyes of the law. And he is afforded what is called HIPAA protection. I'm sure most people have heard of HIPAA. It's the Health Insurance Portability and Accountability Act. It says that doctors and medical professionals cannot share information about a patient without that patient's consent. And if my 18-year-old son is in a coma, he cannot give that consent for that information to be shared. So that's why I state that every single person over the age of 18 should have an estate plan. Now, that estate plan for an 18-year-old does not look the same as the estate plan for a couple approaching retirement. They're very different. But nevertheless, we need to be aware of what the risks are, and that risk is a very viable risk. 18-year-olds across the country are poorer drivers than any other age demographic. It happens. I was 18 once. Many people in the audience here were 18 once, right? Having that protection, that is the only way that parents can make medical decisions, is if their children agree, upon reaching the age of 18, of creating those powers of attorney. And that's why I emphasize that point at the bottom in all capital letters, okay? But I'm going to take it even one step further. As I mentioned, I'm married. Now, I'm a first-generation lawyer. I'm 39 years old. I'll be 40 next month. If I didn't do what I did for a living, there's a very, very good chance that I would not have an estate plan in place. Because statistically speaking, most 39-year-olds don't have estate plans in place. But let me walk through an example here. I leave this presentation tonight, I drive home. Go on Highway 60 and someone crosses a double yellow line and hits me head on. Now, I am in the situation where I'm in a coma and I'm taken to the hospital. Does my wife have the ability to make medical decisions on my behalf? The answer is no. Does she have the ability to find out that I've been admitted to the hospital? The answer is no. It's the exact same analysis. It has nothing to do with our marital status. We are just as protected under HIPAA whether we're talking about a spouse or the man on the moon. It doesn't matter. That's why every single estate plan should have those powers of attorney. Now, so far we've been talking about medical powers of attorney. There's also a financial power of attorney. The most common misconception I run into is this: Wisconsin is a marital property state. Everything my spouse owns, I own with him or her. And again, like many things I find in my practice, there are kernels of truth, but there's some additional information. Because when a married couple says that to me, what I want to say to them is, that can't be true. Because there are some assets that are owned that cannot be jointly owned. And I'm going to list a couple of those common examples. IRAs, 401ks, 403Bs, and life insurance. To the extent that one of a married couple owns any of those assets, they can't be jointly held. But the common response I get is, yeah, but my spouse is the beneficiary on those assets. And what I say is, well, that's great if you die. If you're alive, but you're merely incapacitated, your spouse can't access those assets without a power of attorney. So again, every single person, regardless of age, assuming they're over 18, of course, regardless of marital status, should have these powers of attorney in place. Are there any questions about powers of attorney, what they are, what they do, or why they're important? Okay, seeing there's no questions, I'll move on to the next topic here, okay? When it comes to estate planning, by far the most commonly associated word with estate planning is will. I need a will. I should have a will. I get that call probably 10 times a week from prospective clients. Can you draft the will for me? And the response that I give, I don't typically say this verbally to the client, depending on the client, but typically what I'll say is, sure I can, but is the will the right document for you? Okay? And to break that down and to make that as easy as possible, what I want to do is I want to mention the two things that a will always does, and the third thing that a well-drafted will does when applicable. I use that as the foundation to then move to the next level, which is to explain what a will does not do. And that's one of the big misconceptions that I run into in my practice. So a well-drafted will always do two things. Thing one, a well-drafted will determine who your beneficiaries are. Who or what, in the case of charities, are receiving the proceeds of your estate upon your death. Not only does a well-drafted will determine who receives them, but also under what circumstances. For example, I mentioned before, my two boys are 11 and 8, okay? My wife and I die tomorrow. We don't want to turn our estate over to an 11 and an 8-year-old. There'd be a lot of Pokemon and other things purchased with that money that we don't necessarily want purchased. Not only that, but we can't legally turn it over to them anyway. We can't legally turn money over to beneficiaries who are under the age of 18. Now, we also don't necessarily want to turn that money over to an 18-year-old, right? We were all 18. I can say personally I'm more responsible now than I was at 18. So a well-drafted will not only says who the beneficiaries are, but under what circumstances they can receive and utilize the money. The second thing a well-drafted will always does is determine who's in charge. I'm sure many of you have heard the term executor or personal representative before. By the way, those are synonymous. It's like lawyer and attorney. They mean exactly the same thing. That person's job description is pretty simple. Now, the implementation of the job could be tricky, but the description's pretty straightforward. Their job is to shepherd the assets into the estate, pay out any final expenses, and then distribute the proceeds to the intended beneficiaries. That is the executor's position, and the will allows you to nominate that executor. The third thing that a well-drafted will do, again, when applicable, it's applicable to me, may not be applicable to some people in the audience, but the will is the only way we can nominate guardians of minor children. Okay, that's one of the biggest misconceptions I run into in my practice, that people think that, well, if we have an agreement with our parents or the godparents or the sponsors or the siblings, that they will have the children. The only way to establish guardianship of minor children is through a will. We're going to talk more about guardianship going forward because, again, in my experience and in my personal and professional opinion, that's probably the most important part of an estate plan. Forget the money. I mean, the money's important, but where the kids go if parents both pass away is by far the most important thing. So we'll talk more about guardianship as we go forward. But again, those are the three things that a well-drafted will do. Again, nominate who the beneficiaries are, nominate who's in charge of the estate, and appoint guardians of minor children. Any questions on what a will is? Yes, ma'am.
And it says, if I'm married with no children, and according to state law, all my assets go to my husband anyway, so why do I need a will?
Right. It's a good question. So the problem there is they may go to the spouse, but it's the question of how they get to the spouse, right? So it's not necessarily a function of state law that everything goes to the surviving spouse. It could happen that way, but again, the process on how it gets there could involve something called probate, which we're going to talk about in a little bit. So again, if people have the desire to have assets go where the state law would have them go, that's one thing. The question is how they get there. And oftentimes when you don't have an estate plan in place, the estate will go through probate, which is an expensive process, it's time consuming, and it's all public record. So again, I certainly will touch more on what probate is going forward. But again, in that case, it's not necessarily just a function of having a will or looking at where the assets are going to go. It's what is the time and what is the expense to get them to the surviving spouse. Yes. Yes, sir.
If the executor lives in another state,
Yes.
is that a problem?
It's not a problem. And again, for the executor living in another state, that means that we have a will-based plan, okay? With a will-based plan that goes through probate, which is something we're looking to avoid, if the executor is out of state, a resident agent has to be appointed. Now, oftentimes that resident agent is the estate planning attorney who's probating the estate. So the mere existence of the executor being out of state is not an issue. But as a practical matter, someone has to be appointed as a resident agent who is a Wisconsin resident, who again is typically the attorney who's probating the estate. Any other questions before I move on? Yes, sir.
You really made a strong point for the powers of attorney, especially for anybody who even turns 18.
Yes.
You ever draw an estate plan that does not include a will?
Well, what happens is this, is that the opposite, or I shouldn't say the opposite, the alternative to a will-based plan is a trust-based plan, okay? And when I create trust-based plans, they include wills as well, that, for lack of a better word, supplement the trust. So what ends up happening a lot of times is I will create those trust-based plans that include a will. Now, if I have somebody who just turned 18, who doesn't have much by way of assets, I will just create powers of attorney for that person. In fact, I get that call quite a bit. You did my estate plan 3 years ago. My son or daughter is going to turn 18 next week. Can we set up a plan there? So for that 18-year-old, I'm not going to set up a will or a trust for him, or they don't have any assets. So it's really a function of having assets. So the way I look at it is it's kind of a progression. So once you turn 18, you should have those powers of attorney. Once you have children, you should have the will set up for guardianship purposes. Once you have more than $50,000 worth of probate assets, you should have the trust so that we avoid probate. So, and I have had clients, I've had several dozen clients who've gone through that entire progression with me. They turn 18, they get powers of attorney, they have their first child on the way, they create a will, they acquire over $50,000 worth of equity in their real estate or in assets that are probatable in mass, and then they create a trust. So it's kind of a progression. It's a matter of finding the right tool for the situation. And that tool, of course, changes over time. Excellent. Any other questions then? Okay. So guardianship issues. Again, I know I hit on this one before, but just to kind of re-emphasize the point, because again, when it comes to my practice, I always think about the concept of polling 100 people at Walmart. That's something I say a lot when I give presentations or when I talk to my prospective clients. If I were to poll 100 adults who have minor children at Walmart and ask them the question, if you and your spouse pass away, what happens to your children? I'd say 97% of them would assume incorrectly that guardianship would simply be awarded to whomever petitioned for guardianship. They would not know that the will is the only way to determine guardianship of minor children. They'd simply be unaware of that. So I focus more on this guardianship issue. Another interesting thing with guardianship, and again, first-generation lawyer, they don't teach you this in law school, you just kind of got to learn it on your own, is an interesting fact that I've seen in my practice, that when it comes to guardianship, okay, among my clients who have minor children, a little over a third of those people who create those plans will nominate a non-relative to serve as a guardian. And that kind of came as a surprise to me. I would think most people would pick their parents or a sibling or someone along those lines. But a lot of people will pick family friends. That family friend who's not a blood relation has about 0% chance of being able to go to court and petition the court to serve as the guardian of the minor child whose parents passed away. So to the extent that we as parents want a non-relative, or any person for that matter, to serve as a guardian, then we need to have it in a will, because nothing else will work. I mean, I've even seen references on television shows to notarized documents that say, oh, my parents will get the children. Completely unenforceable. Anything short of putting in an estate plan will require a hearing to be held by the court. Now, the court is going to use the standard, which is a good standard, of what is in the best interest of the child. But how can a court or a judge, despite his or her best efforts, determine that? who better than the parents to make that determination? Because the judge is going to hear testimony. The judge is going to hear a bunch of lawyers prattle on about why their clients are the best at serving as that child's guardian. At the end of the day, it's going to create family rifts. Because if many family members go to court and petition, there's only going to be one winner, that I'll put in quotes. The other ones are not going to succeed in their petitions. So again, who better than the parents to make that decision? So I always make that point because there very well may be people like myself who have minor children. There might be some people in this audience who don't have minor children, but they have minor grandchildren. And they should be talking to their children about creating a plan to make sure that their grandchildren go where their children want their grandchildren to go. So again, guardianship's a very underrated and underappreciated aspect of estate planning, so I try to emphasize it at this point. Any questions on guardianship? Okay. So moving on to probate, okay? The question earlier implicated probate. Most of my prospective clients have heard the term probate before, and they generally have negative feelings about probate, as they should. Where I can get away with it, I can't always get away with it, but where I can get away with it, I try to define things in one sentence, okay? And I'm going to do that with probate. Probate is the process where a court oversees the administration of an estate. I'll repeat that. Probate is the process where a court oversees the administration of an estate. When an estate goes to probate, there's a series of hearings, a series of filings, a series of events that have to occur before assets go from the name of the intended beneficiary, from the name of the deceased to the name of the intended beneficiary. My goal as an estate planning attorney is to encourage my clients to create plans that are guaranteed to avoid probate. And why do we want to avoid probate? 3 main reasons. The first is cost. Average cost of probate in a state right now in the state of Wisconsin is between $5,000 to $10,000. That's an average. Some are more, some are less. Second reason is timing. Average length of probate in the state of Wisconsin is between 12 to 18 months. So from the date of death to the date probate has run its course, typically about 12 to 18 months. Third reason is publicity. Wills are public record. They have to be. Not only is the will public record, but the amount and the character of the assets that pass through probate are also public record. And that's something that most people would rather keep out of the eyes of relatives, nosy neighbors, the government in general. And probate forces that to come to and become available to the public. So those are the 3 negatives of probate. Again, cost, on average about $5,000 to $10,000, timing, about 12 to 18 months in length, and the fact that it's public record. So again, the next question, of course, becomes, how do we avoid probate? And that's where we're at here. Are there ways to avoid probate? Not all assets are probate assets, okay? Assets that have POD or TOD designations avoid probate. And it goes back to the question about that we received from the listener online about how they have a situation where they have a spouse and they have no children. What happens under that scenario if the husband and wife pass away simultaneously? Where do the assets go then? And that does happen. So let me define what POD and TOD are, because I think that's kind of at the heart of the question that was being asked. If wife in this case has an asset and she nominates husband as a beneficiary, can that avoid probate? Does it avoid going through will? The answer is yes, if the beneficiary survives. POD is an acronym, payable on death. TOD is another acronym, transfer on death, okay? These are designations that some assets allow us to put in place. The problem is, if we list human beneficiaries, there's no guarantee that that human beneficiary is going to survive us. So for example, go back to my own situation. As a parent, and I'm sure every parent in the audience can appreciate this and agree with this, we want nothing more than for our children to survive us, okay? But there is no guarantee of that. When we create POD and TOD designations, we are listing human beings as beneficiaries, okay? And there's no guarantee, regardless of how much younger or how much better health that beneficiary is, that he or she will survive us, okay? Again, if a person's net probate estate is worth less than $50,000, so let me back up a half step and explain that. Under Wisconsin law, there's only two ways to avoid probate. Two and only two. Way number one is this, and it ties into that second point here. If we fast forward to the date of death, and the value of the probate assets is less than $50,000, that's considered a small estate under Wisconsin law. Small estates avoid probate no matter what type of estate plan you have, or even if you have no estate plan at all, okay? But here's the problem. Most people have more than $50,000 worth of probate assets. Most people, the equity they have in their home in and of itself exceeds $50,000, let alone everything else they have. So for most of my clients, that second bullet point's off the table because they're over $50,000 worth of probate assets. It goes back to the example we mentioned before, that 18-year-old who happens to pass away, their assets are below $50,000. So there's an easy way to have those assets go to the intended beneficiaries. But for the overwhelming majority of adults, that second bullet point's off the table because we're going to be over that $50,000 threshold. So the only other way to avoid probate is to create what's called a revocable living trust, okay? And this is by far, the most common misconception that I run into in my practice. A lot of my prospective clients will incorrectly think, I have a will, I have powers of attorney, I don't need any more estate planning. And nothing could be further from the truth. Because the only way we can guarantee we avoid probate is through the creation of a revocable living trust, okay? Now, I'm sure every single person in this audience knows what the word revoke means in everyday conversation. The ability to change, the ability to revise, so on and so forth. But when it comes to estate planning, revocable trusts carry two very important aspects. Aspect number one, the creators of the trust have full custody and full control over their assets. See, what I found in my practice is a lot of people think that trusts limit the creator's ability to use the money, or they have to ask permission from somebody. And while there certainly are trusts out there that fit that description, the revocable living trust does not. The creators of the trust have full use, full access over the assets. Again, maybe not the most lawyerly way to say it, but the way I try to impress this upon my clients is your ability to do what you want with what you have is identical before you create the trust as it is after you create the trust. Full control, full access. Second important aspect of revocability is the ability to change the documents. Life happens. It's a cliche, but it's true. People are born, people die, people get divorced, people get disabled. There are any number of reasons why one may want to amend or change their estate plan as time goes on. And with a revocable living trust, we possess that ability. We have the ability to make those changes over time without any hindrance until, of course, we pass away. The revocable living trust avoids probate for a very simple reason that tends to escape a lot of people. And I'll boil it down very simply. A trust can't die, okay? People are going to die. As a human race, we have a 100% mortality rate, okay? The problem, of course, is we don't know when that's going to occur. Younger people predecease older people every single day. If I have a client and they have children, I can't state, of course, with any degree of certainty whether any human beneficiary is going to survive the creators of the trust. What I can, however, state with 100% certainty is that the trust will survive my clients. Because again, the trust can't die. So that's really what it comes down to in my practice, is encouraging people to create trust and to have them get over the misconceptions about what a trust is and what it does, and to explain to them how in most situations a will is simply inadequate because it does not guarantee probate avoidance. Are there any questions about probate or the differences between wills and trusts?
They're reading the different options that you have listed to avoid probate.
Yes.
But they're not quite sure how to do it themselves. They're wondering if they work with you, do you guide them through the whole avoiding probate?
Absolutely. That is fundamental to my practice. The analogy I always use is this, and again, I apologize if this may not be the most lawyerly example, but it really does get the point across. I'd be willing to bet that every single person who's listening to this presentation has at some point in their life purchased a vehicle, okay? And what I'm going to do is I'm going to summarize that process in about 20 seconds. You have an idea about what kind of car you want. You go to the dealership. You test drive a few cars. You find the best deal. You haggle perhaps with the dealer, the broker there, the salesperson. You sign some paperwork. You drive the car off the lot. That's the process summarized in about 20 to 30 seconds. And I'm sure most people can relate to that process, okay? Now, I'd be willing to also bet that in all your time purchasing a vehicle, nobody has ever said to you, no salesperson, no dealer has said to you right after you purchase the car, now remember, you got to put gas in the car, right? That never happens, right? It would be silly to have someone associated with the car sale remind you that you needed to put gas in the car in order for the car to work. Well, I can tell you this. I've been practicing law for 14 years, and that's the best example I can come up with to answer that question. Because here's what I'll say. With all due respect to people in the car business, pumping gas and putting gas in a car is significantly more intuitive than how to fund a trust. But part of my job is to tell my clients how to pump gas into their car. Because just like the car salesperson who sells the vehicle, you can't blame that salesperson when it runs out of gas and you didn't put gas in the car. The car needs gas to work. The trust needs to be funded appropriately to work as well. But part of what I do with my clients is I will give them legal advice as to how to make sure assets go to where they need to go. Because again, it's a cliche, but not all assets are created equally. I'm not going to give the same legal advice for a life insurance policy as I would a bank account, as I would for real estate. There's tax issues, there's ownership issues, but all of that is part of what I do for my clients. Because again, if the trust is not funded properly, it is useless. So it has to be funded properly, and I make a point to make sure that all my clients understand it and that they can follow my written instructions. Thank you. Any other questions? Yes.
Yes. You talked about a house possibly being a probable asset.
Yes.
Can you give examples of other assets that could be affected by probate? And then secondly, you put all those things into the trust?
Any asset that does not have, and I'm going to use a fancy legal phrase, but I'm going to break it down and explain it. Any asset that does not have a named contractual beneficiary is a probate asset, okay? So let me break that down. The key word there being contractual. So again, I'm just going to give a hypothetical, okay? I'm going to give you a little bit of my family history here to help set up this hypothetical. My parents are both alive. They live in West Bend, okay? I have a sister. I'll tell them how the estate plan's set up. It's divided 50-50 between my sister and I. That's how 99% of people would set up their plans. I don't think my parents, if they're watching, would care that I just shared that bit of information. But just to illustratively make that point, okay? If they have an asset, whatever types of assets they have, it doesn't matter what type they are, if they don't have contractual beneficiaries, an agreement with the holder of the asset that says the money goes to the trust, or even to my sister and I specifically, it's a probate asset. So by far the most common example besides the real estate is bank accounts, right? Go back to the polling 100 people at Walmart. If I polled 100 people at Walmart, 100 adults at Walmart, I'd be willing to bet 99 or 100 of them have a checking account. It's pretty common nowadays. It's very rare to find somebody who doesn't have a checking account. But if I changed the question and I asked, how many of those same 100 people who have checking accounts have beneficiary designations on the checking account? That number would fall to like 15 or 20, because most banks aren't great at asking about that, and most bank consumers aren't great at knowing they ought to ask about that. So if you have a checking account, and the holder of that account, whether it's a married couple, both spouses, or a non-married individual, when they pass away, that is considered a probate asset. It has to have a named contractual beneficiary. So all sorts of assets fall away. I frequently run into this. I'll have clients who have things like IRAs or 401ks, and they only list the non-owning spouse as beneficiary. And my question is a very simple one. Well, both of you are going to pass away eventually, right? What happens at that point? The answer is it's a probate asset, unless we have other beneficiaries. But again, there's a difference between naming the human beneficiaries versus the trust, which is why I encourage my clients to create trust, because again, the trust can't die. So if we have the assets funneling to the trust, that ensures that the assets will avoid probate. So again, it's a matter of identifying those assets. That's the first step. We have to identify the assets that we have, and we have to divide them by type, because some assets are pre-tax, some assets are post-tax. Some assets are owned individually, some assets are owned jointly. So depending upon both the ownership and the taxation, that's going to guide the legal advice I give my client on an asset-by-asset basis in terms of how they ought to list their beneficiaries. Okay? Any other questions on this topic then? Very good. So requesting POD and TOD designations. Okay, this is something that people can do on their own. In other words, I'm not naive enough to believe that every single person watching this video who doesn't already have a trust is going to call me tomorrow to set up a trust. I get it. This is something that sinks in over time. So one piece of advice I'm going to give you is this. At a bare minimum, assets should have POD and TOD designations. Okay, and again, POD, payable on death, TOD, transfer on death. Okay. Some assets have that already built in, like life insurance. I mean, let's start with that. Basic concept of life insurance. Even if anyone doesn't have life insurance, they probably generally know how it operates, right? I sign a contract with my bank, or I'm sorry, with the holder of the life insurance. And the contract reads as follows. I agree to pay a premium in exchange for their promise to pay out a death benefit to the people that I name once I pass away, assuming I pass away within the terms of the policy. Well, of course I'm going to name a beneficiary for that. Why wouldn't I? I mean, that's the whole purpose of getting the life insurance. So some of those assets already have that built in. Same with the 401k. Most of the time when you get a 401k through an employer or privately, however it works, the first question they'll ask you is, who are your beneficiaries? So some of those assets already have that built in. The others you have to request. I talked about that earlier with the bank accounts because the question kind of led me to that. Bank accounts generally don't have beneficiary designations because clients and the banks have not requested them, but they exist. If you went to your bank and you asked them to place a POD or a TOD designation on your account, they do so for you so that it's an instruction to the bank to say, pay this amount to this person or to these people or hopefully to my trust once I pass away. But I did want to go back to a point because I didn't fully answer one of the questions before, at least to my satisfaction. I emphasized the word contractual beneficiaries, okay? Whether or not you realize it or remember it, when you created your bank account, you entered into a contract with the bank. There are terms and conditions associated with you having that account at the bank. That's a contract, okay? Neither a will nor a trust is a contract, okay? So a common example I'll say is this. Go back to my example I mentioned before. Let's say my mom and dad had wills in place. They don't. I created a trust for them. But let's say they had wills, okay? And their wills say, every asset that I own of any type, any kind, is to be split evenly between my son and my daughter, okay? And they have a bank account. And like 85 to 90% of people, they didn't have beneficiaries on that bank account. Is that a probate asset? Absolutely it is. It doesn't matter what their will says, divided 50-50. It's still going to probate because it's not a contractual beneficiary. It's a beneficiary established through either a will or through a trust. So that word contractual means something. That word contractual differentiates it from the language in an estate plan that says my intended beneficiaries are my son and my daughter. So it's very important to make sure we have that. And again, having to make sure that that person is alive, that's also very important because again, my parents could have my sister and I as beneficiaries on their bank account. If my mother or my father outlives my sister and I, guess what? We still have a probate asset. But again, if we have a trust, we avoid that because again, the trust can't die. They might also lack flexibility. And let me explain this concept. And in so doing, I'm going to use a situation with my grandmother. I find that's the easiest way to explain that, okay? My grandmother is in her mid-80s. My grandmother had 5 sons, okay? Her initial intent was to divide everything 20%, 1/5 to each of her 5 sons. Pretty straightforward. I, of course, asked my grandmother the question, what happens if one of your sons predeceases you? My grandmother's response, of course, was, that's never going to happen. Of course, that was her response, right? So we draft the document. I said, Grandma, we should still account for it. I said, let me broadly explain what the 2 most common options are as it relates to how assets are dealt with if a beneficiary predeceases. By far the most common, 90% of my clients will say, if a child of mine predeceases, I want his share in this case, since there's 5 sons, to go to his children. My dad and my 4 uncles all have children, so they want it to go to the children, okay? By far the most common. The second most common is to have it be split among the surviving sons, right? So the idea would be if one of the sons predeceased, it would go to the surviving 4 sons. Again, either way is fine. The problem is when it comes to POD and TOD designations, we don't have that flexibility. When we have POD or TOD designations, it can only be option 2, that it just goes to the survivors of that group. So to the extent we want it to go, in this case, to the grandchildren of the deceased brother, we need to have a trust in order to create that, because we cannot rely on POD or TOD designations. And as fate would have it, 2 of my uncles have passed away in the past 7 years. So we're down to 3 now. So again, adjusting the plan accordingly, and that's another important issue too. We can't predict who's going to pass away when. In my grandma's situation, we adjusted things based upon who passed away under what circumstances. All those things are to be considered because, again, that's another trigger, death. Somebody passes away, it may cause you to want to update the estate plan, and in her case, we obviously did. Are there any questions on what a POD or TOD designation can do and what the limitations of those designations are? Okay. Certain assets cannot have POD or TOD designations, okay? And I've just listed a couple of those assets here, because what happens is this. The magic number that I've mentioned many times during this presentation is $50,000. Even if we knew, which of course we don't, that all of our children are going to survive us, and we have those POD and TOD designations, is the estate guaranteed to avoid probate? The answer is still no, because to the extent that these assets in the aggregate, in total, exceed $50,000, we're still going to probate. So I have clients, like I mentioned, I have a client who has a coin collection that's worth well into the 6 figures. Well, that asset alone puts him over that $50,000 threshold. So he needs a trust to ensure that his estate avoids probate. So these are just some common examples of items that people own that could, in the aggregate, exceed $50,000. Now, don't get me wrong. I have some clients who don't have $50,000 worth of probate assets. I have some clients who don't own real estate. They live in an apartment, they have a modest car, their assets are well below $50,000. For those clients, will-based planning is more than sufficient. Similarly, I have a lot of clients who are just starting out in life. Maybe they just got married, maybe they're expecting their first child and they're still renting. Will-based planning is more than sufficient for them because probate is not going to be implicated if we have less than $50,000 worth of probate assets. But we have to look at the totality of assets. We can't just look at what we traditionally consider assets as far as our net worth, the real estate and the checking accounts and the retirement accounts. We have to look broader than that. We have to look at all the assets that a particular person or a particular married couple owns. And these are just some examples of common assets that people own that could make the estate have more than $50,000 worth of probate assets, insofar as we would still need a trust anyway to avoid probate. So what is a revocable living trust and what does it do? Okay, I know I've kind of hit on this one before here, but just to make sure that we're on the same page here, the key aspects of a revocable living trust are that the creators of the trust have full control and full access, full use of their assets until the day they pass away. People don't create revocable trusts for tax reasons. I hear about taxation quite a bit, okay? This is not a tax issue. Revocable living trusts are what are called tax-neutral documents. They don't help with taxation, but they don't hurt with taxation either. People create revocable living trusts to get that guarantee that we avoid probate. We avoid the $5,000 to $10,000 cost, we avoid the 12 to 18-month delay, and we avoid the fact that it becomes public record, okay? But when it comes to its actual operation, the trust is very similar, and it really is no different in terms of what your day-to-day looks like than if you had no estate planning documents or if you had a will. It's just upon the death, we get to have the ability to guarantee that we avoid probate. Again, the cost of creating that revocable living trust is significantly cheaper than the alternative, okay? And that's one of the things that I try to encourage my clients to think about, because I get it. A lot of people get nervous about the prospect of attorney's fees and things like that, but the value promise I make to my clients is a very simple one. The cost of creating the estate plan is significantly less than the cost that would be associated of not creating an estate plan. That's the value I try to bring to my customers. I want to talk about this last point in detail here. Providing privacy and creditor protection, because I want to clarify what that means. A lot of people will think that, let's say my wife and I create a trust, okay? And let's say we decided to be deadbeats and not pay any of our bills. Could we say, well, the assets are in trust, they're in trust, you can't touch them? The answer is no, we can't do that. The trusts are not protected from creditors of ours. They are, however, protected from our children's creditors. And let me explain what I mean by that. Because the trust is revocable, my wife and I, in this case, would possess the ability to make whatever changes we want at any time. So right now, our plan may say 50-50 to our 2 children. That's what it says right now, I'll tell you that. But if events occur down the road, we could change our mind. We could decide to leave it all to the Humane Society if we wanted it to. I have a client who did that, by the way. I'll tell a funny story about that. I had a client who was in a situation where she told me she had 2 children. I just assumed incorrectly that she wanted to divide it 50-50 between them. She said, nope, everything to the Humane Society. And I write it down. That's my job. My job's not to judge. And she says, you're probably going to wonder why I did that. I'm like, yeah, as a human being, I'm a little curious. As an attorney, I don't care. I'll do what you tell me to do. But as a human being, I'm curious. And she says, my kids constantly let me down. A pet has never disappointed me. I said, wow, that's pretty compelling. So I guess that's my point, right? Because we have that ability to make those changes, it's built in that way. So this is the example that I want to give, and I'll use my own sons as an example of this, okay? I'm going to fast forward to the day the second of my wife and I pass away, because it's going to happen. It's going to happen to all of us, okay? Fast forward to that moment in time. Can I state with any degree of certainty that either of my children will not be going through a divorce at that time? Of course not. Can I state with any certainty that they won't be going through a bankruptcy at that time? Nope, can't do that either. Can I state with any degree of certainty that they will not have a gambling, a drug, or an alcohol problem? No, I can't. That's the big difference between a trust and relying on beneficiary designations. When we have a POD or a TOD, the key word is O, or the key letters are OD, on death. If we have our children listed as beneficiaries, they get the money the moment we pass away, without any conditions or any other thoughts associated with it. On the other hand, if we have the trust as the beneficiary or the owner, the trustee, the person in control of the trust after the creators pass away, has the ability to withhold that money until the divorce is finalized, until the bankruptcy is adjudicated, until that person is able to get treatment for their drug, gambling, or alcohol problem. So that's a huge advantage of trust-based planning, being able to control that asset and being able to make sure that it doesn't end up in improper hands. Any questions on what a revocable living trust is or what it does? Very good. So, again, I'd like to thank you for this opportunity here today. I'd like to open the floor to any general questions, any specific questions. But again, just want to thank Kettle Moraine Lutheran for this opportunity. And like I said, if I can be of any further service to any of you, please let me know. Thank you very much.
Talk about a revocable
Yes.
trust. There must be an irrevocable trust.
There is an irrevocable trust. Now, an irrevocable trust, again, as I'm sure you can imagine just by hearing the word, means that changes cannot be made. Okay. Now, a lot of people will say, well, Rob, you just explained many times why being able to make changes is a positive thing. Why would I want to limit myself in terms of my ability to make changes? And the answer is people will use irrevocable trust in 2 very distinct situations. Distinct situation number 1 is where we don't want a beneficiary to have unlimited access to the funds. So for example, I did a trust a couple years ago for a husband and wife who were both medical professionals. One of their parents was passing away and wanted to leave a significant sum of money to their child who just turned 18. And the parents were concerned that if that child had unfettered access to the funds and could do whatever they wanted with it, that they may not go to college. They may not pursue the right things in life. So we limited that trust and didn't give that person the ability to make changes. But by far the most common use of irrevocable trust is to protect against nursing home estate recovery. Again, that's a whole nother topic that I could spend several hours talking about. But to answer that question, when assets are in irrevocable trust, they can be protected from nursing home estate recovery, but there's a 5-year look-back period, and there are oftentimes significant tax consequences for doing that. So that's something that is a much more nuanced discussion. In other words, the decision to create the revocable living trust, in my humble opinion, is a no-brainer, right? There's no downside to creating the revocable living trust because there's a 100% chance the estate will go through probate if we're over that $50,000 figure. The decision to create the irrevocable trust, on the other hand, is a much more nuanced one. Because, and again, I'll say this for myself, I'd say it for anybody in the audience, right? We have no idea whether any of us will ever spend a day in a nursing home. We just don't know. Furthermore, we have no idea whether any of us will ever spend a day in a nursing home when we need the government to pay for that care. We don't know that. And by creating an irrevocable trust, one that cannot be changed, we're setting ourselves on a path for an event that may or may not ever happen. So that's a much more difficult decision and something that requires a lot more understanding of the pros and cons to figure out whether the irrevocable trust is the right plan. What I always tell my clients is this: when it comes to nursing home issues, I get it. I get why people want to protect their assets. An average cost of a nursing home right now is about $12,000 a month, right? That can drain an account very quickly. The problem then becomes, what are the consequences of doing it? Because what I can tell you is this, and again, I make it a point, I don't get political. You have your politics, I have mine. But what I can tell you is this: for every dollar that people in Wisconsin protect from nursing home estate recovery, the taxpayers make up the difference, right? So as a result of that, the state, regardless of where you fall politically, the state has an incentive to make it difficult for people to protect assets. So I can help people with the pros and cons in explaining that, but again, much more nuanced and specific discussion there. But those irrevocable trusts do exist. Any other questions? Yes, ma'am.
What is an average cost to create an estate plan?
Okay. That's a more difficult question. That one I have to nuance here, right? Because, again, there's a difference between whether we have a married individual, a married couple, or a non-married individual. Married couples, it's not going to cost twice as much, but it's going to be more than a non-married individual. Real estate, how many parcels of real estate do they own? Do they own just the one home? Do they own all that? One thing I can tell you is this, and hopefully I'm not going above my parameters here in this discussion, I apologize. One thing that I do offer my clients is what I call a referral discount. So if you tell me that you listened to this podcast, that you heard about this, you're affiliated with KML, I do afford a 20% discount off of all services. One thing I can tell you when it comes to trust-based planning, my average cost to do a trust-based plan for a married couple is less than half of the bottom figure of going through probate, which is about $5,000. So on average, I'd say for a married couple, you're looking at somewhere between $2,000 and $2,500, which again is half of even the lower limit there. Plus you get the powers of attorney, guardianship for minor children, all of that is part of the estate plan. And the other thing I will tell you again specifically about my practice, I can't comment on other attorneys, but I don't charge for revisions to documents. Because again, life happens, right? We have people who want to make changes because of life events. Oftentimes other attorneys will charge a fee to revise documents. I don't do that. My goal is to build a relationship with my clients. Probably the thing I'm proudest about of my practice is I have over 100 families where I represent multiple generations. I'll do estate plans for grandparents, parents, children. So I try to be fair with my clients, and I try to make sure that they're understanding the value of what they're receiving. Yes, sir.
Comment on the differences between, let's say, a bank account with joint ownership versus POD or TOD.
Okay, so joint ownership reflects on who owns the asset during life. Okay, so while you can have two people own an asset during life, that could be the same or could be different than having a beneficiary upon death. So let me just answer that question in kind of a roundabout way, right? One of the common things I'll see in my practice is you'll see an elderly parent putting their child as a co-owner on the account, okay? They, under that example, are joint owners on the account. That's joint ownership. Even though in 99% of those circumstances, it's mom or dad's money, we just have the child on as a co-owner to make it easier, right? Because if mom or dad passes away, it goes to child. As an estate planning attorney, that is not the best situation to be in. And let me explain why, okay? So I'm just going to use my own example, so bear with me here. I find it's easier to explain by example. Okay, so I'm going to take my parents' situation, okay? Men typically pass away first, so under this example, I'm going to have my father pass away. My mother is the surviving spouse. She may say, it'd be a pretty good idea to have the one lawyer in the family as the co-owner on that account. So she may put me as a co-owner on the account. Now, I would object to that because it's not a great idea, and I'm going to explain why it's not a great idea. Reason number one is this: that is all her money. What if I get divorced? Could happen. Half the marriages in this country end in divorce. What happens then? Guess what? That's considered a marital asset. It doesn't matter whose money that is. My name's on that account. Half of that money is going to be considered mine for purposes of a divorce. I drive. What if I get in a car accident? What if I don't have sufficient insurance to satisfy a judgment? Guess what? They're going to go after that bank account. But here's the bigger one. My mom passes away eventually. I and my sister survive her. They have a will or a trust in place that says divide it 50-50. If my mom and I were co-owners of that account and she passes away, my sister gets 0 from that account. Now, I may have a moral obligation to pay my sister, but I certainly don't have a legal one. So joint ownership is never a good idea because we can get all the benefits of joint ownership with none of the liability. And how we do it is we have a power of attorney in place. My mom makes me her power of attorney. And as the power of attorney, I can help out with things. I can sign checks for her. I can run to the bank for her. And then, for the death aspect of it, we list beneficiaries. Now again, ideally we create a trust so we guarantee we avoid probate. If we're not going to do that, at least go to the bank and have my sister and I as 50-50 POD beneficiaries. So if we happen to survive her, then we avoid probate that way. So joint ownership is almost never a good idea. And where that really comes into play is with real estate. I get that a lot. Maybe I should just add the kids to the deed or deed the home to the kids. Well, it's all those problems I mentioned before. Divorce, insufficient insurance, but the other one there is capital gains. Capital gains have been in the news a lot lately, okay? But what I can tell you is this. There is an exemption from capital gains for the sale of a primary residence. Here's the problem, though. Most adult children, certainly not all, but most adult children don't live with their parents. So if they're on the deed and the house sells, they don't get the step up in basis to avoid capital gains. They're going to pay significant capital gains on the property. So again, I'm from Washington County. I have a lot of clients in Washington County. Even yesterday, as easy as yesterday, I was in a house where the couple had been there for 63 years. They've owned the house for 63 years. Of course they paid a lot less for it then than it's worth now. The good news is when we create a revocable trust, when the second of the two parents pass away, the kids get what's called a step-up in basis. They don't incur any tax when they sell the real estate. If we conveyed it to an irrevocable trust, they would, because it's not the irrevocable trust primary residence. So again, there are many considerations that have to come into that, but as a general takeaway, joint ownership of assets, when it's a child co-owning it with a parent, 99 times out of 100 is not going to be a good idea. Yes, sir.
Taxes are due, and is it better for the trust to pay the taxes or the beneficiary?
Neutral. Now, what I can say is this. It depends on the circumstances. So, as a general rule, okay, and I'm going to make some generalizations here because there's a lot of different things at play. What I can tell you for certain is this. As we sit here right now, Wisconsin does not have an inheritance tax. Could that change? Of course it could change, but right now it does not, okay? Secondly, the federal estate tax threshold for a married couple is at $22.8 million. A non-married individual is half of that, $11.4 million. I don't have clients who are above that threshold. In fact, when I do, I send them to an attorney in Milwaukee because there are many, many, many more issues that we have to deal with, okay? But for those clients, taxation's not an issue. On an estate or an inheritance level, there are always income tax considerations, particularly when we're dealing with retirement assets. So take a garden variety IRA or 401k. That is money that you put in on what's called a pre-tax basis. You didn't pay tax on that money when you put it in. The idea is you put that money in when you're earning a lot of money, and you take it out when you're retired and not making as much money. The problem comes when you pass away. Now, I've been practicing law for 14 years. I've never once had a client say to me, Rob, I want my kids to pay as much tax as possible, and I want them to have as little flexibility as possible. And I don't think I'm ever going to run into that client, right? The idea is just the opposite, as little tax and as much flexibility. So depending on how those assets are set up, it's ordinarily the case that we actually want to keep those assets and only those assets outside the trust and have those assets pass directly to the beneficiaries, but have every other asset go to the trust. So again, the question that was asked before about what role do I as the estate planning attorney help in guiding my clients to list beneficiary designations, That's exactly the discussion we go through. We identify the types of assets, we learn more about the income levels of the beneficiaries, and we make determinations as to whether assets should bypass the trust, which again is very infrequent except for retirement assets, and then which assets should go to the trust, which ordinarily is everything but the retirement assets. Any other questions? Yes, sir. The wheels are turning. I'm happy to get you over that tipping point.
Thinking of capital gains
Yes.
tax,
Mhm.
and again, the beneficiary of the trust
Right.
paying the taxes on capital gains.
Yes. When it's a capital gain, then it's a step up in basis. So long as the realization event doesn't occur, i.e. the sale of that appreciated asset, it's not going to matter whether it's going to the trust or the person. Where it does matter is on assets that aren't subject to capital gains, they're subject to ordinary income taxes. That's the difference. When you have a retirement asset like an IRA or 401k, that's an income tax issue. When we have an asset like an appreciated stock, that's a capital gains issue. What I'm saying is it's neutral as it relates to the second group. When it comes to stocks and other appreciated assets, it's anything but neutral when it comes to traditional garden variety retirement accounts. Are we there? Or close enough? we can talk after too if you want, but again, any other questions for me then? Very good. Well, again, thank you for the opportunity. If anything else comes up along the way, feel free to contact Paul or contact me. Thank you so much.
Thank you, Rob. Those of you that are here, there's a packet of information on your at your seats. There's a lot of information in there that I tend to give to people when working in an estate plan. They're just resources, just information. Take along with you if you'd like. Those of you watching online, if you have no idea what I'm talking about, contact me, and I certainly want to share those with you. I think there's some real value there in the planning process. I'm not the attorney. I don't draft the documents. I don't guide you through the final result, but I will give you the information that's going to help you be equipped to meet with the attorney and be organized. We've often talked, and I know Rob and I have said this many times, this is information. This is the first step. And too often we find people that'll say, you know what, I really appreciated this. Yeah, I got to do something someday. And they never get around to it. Take the second step. Take the action. Get it done. It might be overwhelming to you. It might be very confusing. Maybe tonight you're listening going, man, my head's spinning. But understand that every situation's unique. Every situation's different. Your role is simply tell the attorney what you want to do. And I think, Rob, you even said before, don't worry about the law. You will make it legal.
That's one of my favorite expressions.
Maybe I shouldn't say this as a lawyer, but forget the law. That's exactly it. What are your preferences? If you had the ability on your deathbed to determine where you wanted assets to go, how would you do it? Give me that information, and I'll make it legal. I'll make it binding.
State law is some of the most complicated law there is, and that's why you need somebody like this that can help you. But you know, the other gift that I found in working with Rob is he makes it so easy. I think you've learned just listening to him. He's very easy to work with, very easy to understand, and so if you have this perception of what attorneys are, I think Rob breaks a lot of those molds. Another thing I want to mention, and that's largely because of the role that I have here. A lot of times people can use their estate plan to give a charitable gift. It's really a great opportunity, and one of the things that I tell people, anybody who works in this area of mission advancement work knows that people can be very faithful in how they support their favorite charities. But a gift from their estate plan can really be significant in ways that you don't even understand. You might say, you know, I like giving 10%. I like to tithe. I want to give 10% of my income to my church or to other ministries. And that's wonderful. But if you said, I want to do the same thing with my estate plan, I want to leave 10% of my estate plan. Just think about that for a minute, what that could mean. First of all, it might be the largest gift you've ever given, and the impact that that will have as well. But there again, there's certain ways to do it that really is going to benefit you and the charity. And so at that point, you know, if you're talking about a gift, charitable gift to Kettle Moraine Lutheran High School or the K&L Foundation, talk to me, but you also want to mention that to the attorney, because they'll structure that in a way that doesn't hurt you, it actually helps you and will help the charity. I think too many people think, you know what, I might have to give money to the government, I want to give money to my heirs, my loved ones, and I'm afraid if I give something to charity, it's going to take money away from my loved ones. A well-designed plan is maybe saying more like, let's give less to the government so we give money to charity and still not hurt our heirs. And so there are different ways that the attorney can help you with that. Also want to mention, every month I'm doing vlogs, blogs, and podcasts. There should be some kind of a rhythmic, something to that. Anyway, check our foundation website. You can watch those every month. In fact, this past month I had Rob as a guest. So great opportunity, short segments, but you can learn something specific about a certain area of estate planning. I think they've been really informative and kind of entertaining. I encourage you to look at those. And then lastly, this was an estate planning seminar that we really wanted to share information. Next Tuesday, June 15th, I'm having another event, a little different than this. This is going to be more of a workshop where we're going to sit down and I'm going to help you actually get ready to meet with the attorney. And so if you have questions about, I'm not sure how to do this, or what does this mean, or whatever, we're going to spend just an hour. When you walk out of there, you will probably be equipped to say, you know what, Attorney Melick, I'm ready to sit down with you. I have everything ready. That can be really practical. It's usually a small group because of the format and so forth. But if you're interested in something like that, contact me. Would love to have you join me. That'll be next Tuesday, June 15th, 6:30 right here at KNOW. Thank you very much. Thank you, Attorney Melick. This was very valuable, I believe. Thank you for everybody who attended in person and online. And again, if you have any information, any requests for information, contact us. We'd love to be able to provide that for you. Have a great night.